Welcome to Conozca sus derechos, Know Your Rights. This program is brought to you by the Hispanic Bar Association of Central Florida. I am Camila Pachon Silva, the Community Relations Chair for the organization, and it is my pleasure to be here with you today. The mission of the show is to inform the community of important legal issues affecting us today. Today we'll be talking about elder law planning and how it relates to estate planning. Our intention is not to discuss political opinions, but rather to simply inform the community of relevant topics. Today, I am extremely honored to have two amazing speakers with us. We have attorney Silvia Ibanez, owner and principal attorney of the Law Office of Silvia S. Ibanez, who specializes on wills, probate, guardianship, as well as small business counseling. We also have the Honorable Judge Jose Rodriguez, Circuit Judge of the 9th Judicial Circuit, currently presiding over the probate, guardianship, and mental health divisions. So let's get started again. In past programs, we've discussed about the different tools of estate planning, the will, the trust, the medical directives. So if somebody has all these documents prepared, are they ready for the golden years?
Well, the golden years, we're speaking about retirement and when we possibly can become disabled prior to death. And no, it doesn't quite prepare them for all. It prepares them for all the legal aspects of estate planning and what happens during those years. But if they want to be prepared financially for what happens during those retirement years and years when they're disabled, then they really have to address that issue of elder law planning.
Okay, so you talked about becoming disabled. Many people nowadays have to live with that disability. Can you expand a little bit on that? What does it mean to live with a disability?
Many of us don't want to think about disability or incapacity, specifically if it's a prolonged disability or incapacity. And we have many misconceptions about it. We think that if we're over 65 and we have Medicare, Medicare is going to cover every single financial expense during that retirement period. And that is a real wrong and bad misconception that we have to clear up right away. Medicare does not cover any kind of facility other than short term, and typically it's just a few months after a hospitalization in a rehab facility. After that, you're paying out of pocket. So when you're paying out of pocket, you are basically dwindling down your estate. You're dwindling down and spending down all your assets unless you do some planning.
So what can you do?
Everything you've saved, in other words, everything you've saved is gone because of whatever catastrophic illness has become you, whether it's dementia or something like that. That's the pretty sad thing about not planning.
So what can you do to prevent this from happening? What does that planning entail?
Well, unfortunately, we don't have a crystal ball and we don't know who's going to go through a disability or incapacity period or not. So we all have to plan. And the planning involves considering different alternatives. You can be very affluent, be very, very wealthy, and say, I don't have to do much planning because I have so many millions of dollars that I can just pay as you go to the most expensive facility and no planning is required. There are very few of us in the general population that can boast of that option. A second option is to go to an insurance professional and buy long-term care insurance. We abbreviate that and call it LTC insurance. But if you buy that, you can purchase what's called nursing home insurance, or you can buy a home care rider to that insurance policy, which means you want that same level of care, but at home, and it's paid for by that insurance policy. The third option, and that's what I call many times a crisis option, is when you haven't done anything else, then you plan for qualifying for a Medicaid bed, and we call that Medicaid planning. And some people say that's synonymous to elder law planning, but it really isn't just a direct synonym for elder law planning.
So going back a little bit, can you expand as to what is the role of Medicare before we jump into Medicaid? What does Medicare do?
Medicare is there to provide for senior citizens in America a guaranteed way of paying for all the health insurance problems, all the medical problems that can happen to you. But we do not think of dementia and living in a retirement facility, or dementia where you're living at home as a medical problem covered by Medicare. Medicare is just not intended to do that. And so we really have to understand that the only government program that does pay for nursing home under certain eligibility requirements is not Medicare, but Medicaid.
Okay. And talking a little bit more about long-term care insurance, that seems to be the best option if you do plan ahead. When should people consider buying this type of insurance?
You can really start anytime that you are already in a retirement or pre-retirement mode. You don't want to start too early because you're going to be paying premiums for a long time.
Yeah.
However, I would say anywhere around 55 would be a good time. You're in a pre-retirement mode. And you can do a lot of things to bring down the premiums. You don't have to pay for unlimited nursing home care. The statistics show that once we need skilled care, and we use that term a lot, skilled care is equivalent to nursing home care. Once you need skilled care, your general physical health starts to deteriorate. And so typically you only need coverage of insurance for an average of 5 years.
Wow. Wow. So let's say that unfortunately this family didn't plan ahead and they didn't buy insurance. What are their options now? Is Medicaid their only option? And if that's the case, what does that planning entail?
The planning entails qualifying as an indigent person. And that means you have to make yourself eligible as far as your income. You have to be below certain income guidelines and some asset guidelines. And if you happen to be before Judge Rodriguez, for example, because that person has dementia and there's a guardianship in place, you can't just do that by the seat of your pants because you're the guardian. You would have to go to Judge Rodriguez and ask probate court to allow you to do some of this planning.
And usually the court allows that, or what is the process to get that?
We go through the incapacity determination, and once that's done, then the lawyers generally ask for the opportunity to put together a special needs trust. And then, based on what's been decided by the court, they will go ahead and they will apply for the funds. They will do whatever they need to do to put money aside, perhaps in a trust, divesting the individual of those funds, determining or allocating them to other sources, to other individuals, and again, applying to the federal programs like Medicaid for them to be assisted.
So can you expand a little bit as to what are the requirements when it comes to income and when it comes to assets for a person to qualify for Medicaid?
Well, because this is a very brief show, brief program, I'm going to limit myself to the example of a single person. So I assume that the first spouse has died. If you are unmarried, single, divorced, and your spouse has died, you're a widow, you must have $2,000 or less of countable assets. Remember that word, countable assets. And then as far as income, you must have less than $2,199 of income, $2,199 of income, which is typically 3 times what the SSDI rate is, Social Security Disability Income rate is.
Okay, so that sounds extremely low, almost not realistic. Is it possible for a family of middle class to qualify for Medicaid?
Yes, there are many attorneys in the state of Florida who are very well qualified to do and conduct elder law planning for a family that has excess assets, more than $2,000 of countable assets, or excess income, more than $2,199 of excess income. And when I say that, I want to say that some of the strategies involved don't mean that you can gift money away. You cannot gift money away to family members to qualify. So I know that there are some people that want to do this on their own. They study on the internet and they say, oh, well, I know how I can qualify, so let me start gifting here, gifting there, gifting everywhere. And those are prohibited transfers.
And it's interesting to note how careful I was in discussing exactly that because it is an extremely complex area of the law.
So let's talk about fairness. Is it fair for a family to make them, or for an individual to make himself or herself indigent to be able to qualify for Medicaid? Does that serve the public interest?
I'll let Judge Rodriguez answer that. What do you think, Judge Rodriguez?
Oh, I absolutely. I think there's nothing wrong with it. If we have allowed under the law for folks to plan for that, and if there are instruments that can be drafted for that, it's there. There is no one who can, well, I guess you can tell me, but there's no one who can make me believe that it is fair to go ahead and everything that you have worked so hard for, to divest yourself of that by paying for nothing more than, what life has given you in the way of a debilitating disease or dementia, and to the point of being zero and being destitute. So I think that planning in that manner, because it is legal and because it is allowed, is not only fair, it's appropriate, it's the same thing to do, it's the intelligent thing to do.
Perfect. Well, on that note, let's take a little break. We'll be right back and we will continue discussing more aspects of the elder law planning. Welcome back to Conozca Sus Derechos, Know Your Rights, a program brought to you by the Hispanic Bar Association of Central Florida. I am Camila Pachon Silva, the Community Relations Chair of the organization. Today we're discussing the important topic of elder law planning and why it is important for your family. We have here with us Attorney Ibanez and the Honorable Judge Rodriguez. So let's continue discussing the topic. What happens if we waited too long and unfortunately the person is already suffering from dementia? Is it too late?
No, if you have a son or a daughter that you, prior to getting dementia, empowered as your agent in a durable power of attorney, properly drafted durable power of attorney, and you have empowered that person to carry on this elder law planning or Medicaid planning, then it still can be done. But if you don't have a power of attorney, then you do have to go visit Judge Rodriguez.
For the guardianship.
Okay, so just walk us through that guardianship process again. I know that we've discussed it in previous shows, but as a refresher, what does it entail? Well,
there are petitions that are filed to determine whether or not someone is incapacitated. Mm-hmm. Depending upon the timing and the need or the speed or the need for speed, you can have someone coming in requesting to be appointed as an emergency temporary guardian, and again at that point we have the incapacity hearing. There is an examining committee that we appoint to basically take a look at the individual and find out what the level of incapacity is. Sometimes the individual will be totally incapacitated, which means that we have to have a guardian both over the person for medical decisions and over the property to make sure that the financial needs of the property, for example, if the person is still at home, whether or not who pays for the mortgage, who pays for the electricity, who continues to do that. And again, usually what I try to do is I try to look for a family member, because a family member hopefully is not going to cost money as a professional guardian would. But if there are no family members willing to take the responsibility, then of course we go to a professional guardian. After the time of the emergency temporary guardian, when the examining committee comes back, we'll go ahead and do a review, and at that point we'll see whether or not the emergency temporary guardian needs to continue to be now moved into the guardian of the and you can have two people, one that is the guardian of the person, the other one the guardian of the property, with each with the distinct responsibilities for caring.
So Judge, you mentioned different degrees of incapacity. What happens if the person that needs a guardian, is still able to make some decisions? For example, they want to be able to remain at home. Is that possible?
Well, if I find based on what the doctors and a layperson, usually it's two doctors and a layperson that will report to the court on the level of incapacity, and they will go ahead and check and tell me what they believe the person can do. For example, sometimes we'll go ahead and say, no, you don't have the sufficient capacity to be able to make decisions on whether to marry, whether to vote, whether to determine what your social ambient is going to be, to determine where you're going to live. Those types of powers can be, again, delegated, taken away, or of course, you can't delegate the power to vote, but other powers can be delegated to the individual who is going to be the guardian.
Okay, so you mentioned that in some cases you can have two separate guardians.
As well as a limit. You can even limit.
Okay, well that was my question. So does it mean that if a person goes through the guardianship process and gets a guardian appointed, does that mean that that guardian will have access to the person's assets?
You can. If again, the person is unable to make decisions regarding their property, regarding how to maintain their assets, how to invest, you can wind up having a guardian that has those powers over the property. It doesn't have to, there's a difference, I guess. The terms that we use are a plenary guardian,
okay,
as opposed to a someone who is
limited
or partially responsible for for exercising some of these rights on behalf of the ward.
Okay.
And when we talk about access, as Judge Rodriguez has well said, it is a type of limited access. So when a guardian is appointed, Florida law is very clear that unless the judge wants to be extremely generous to this guardian, which usually judges just follow the book, they're either going to require that all the liquid assets, cash, CDs, mutual funds, stocks, bonds, be in a restricted depository account, and or they're going to require that the guardian be bonded. That means post a surety bond, so that if this guardian were to, by some means, devious means, take all this money and go off and live in Tahiti, that the bond, which is issued to an insurance company, pays the estate of the ward back all this money that was embezzled.
And I wish I could tell you that there's never been a situation where someone hasn't walked away with assets of a ward. That's not
the case.
That's not the
case.
case.
But there's safety guards in place to prevent that.
Sure. And I'm the big pit bull that is supposed to guard over all of that.
Perfect. So what else does it entail, this elder law planning? What other planning steps do we have in this process?
Well, you do need to evaluate. You were talking about, do you stay home? Where do you want to live? It's very important to take residence and residential decisions. Do your homework well ahead of time. You also have to do homework as to your funeral arrangements. Do you want to have a burial, cremation? All of this happens during the pre-disability stage. If you don't do it, I've seen situations where mom or dad, didn't do planning, and then when the mom or dad passes away, one child wants to have a burial for the parent, and the other one wants cremation. Well, you need someone to do this, and sometimes you don't have time to go to court to start a probate proceeding to get someone named executor or personal representative to make that decision. I mean, the body does not wait that long. So it's really essential to do some kind of pre-planning as to what you want to be done with your body. Do you want to donate organs, for example?
And then I will tell you that there have been many instances, some of them recently, where folks spend, because there's no direction on how much to spend or what to spend on funeral arrangements. I had to a request to approve $9,600 worth of funeral expenses. $5,000, approximately $800 of that was for unspecified services. Services rendered. I wish I knew, because it was broken down into a floral spray. 2,000 of that was broken down. I approved the expenses that were broken down, but the 5,000 that were not broken down did not get approved. I don't know whether they had a party. I don't know whether it was for the catering. And believe it or not, I've had requests to pay for catering. And quite frankly, although I think that that's something that may have been very necessary for the family to properly grieve, I don't think that it's appropriate to take that from the estate.
Correct.
If you as a family member deem that that's necessary to let Aunt Tilly pass, or Aunt Maria Pilar, as we talked about in an earlier segment, well, that's okay. But that's on you, not on the estate.
Right.
Unless you in your will,
Decide to do
Tia
so.
Maria Pilar says,
This is what
go
I
ahead
want.
and hire a caterer and bring out the conga drums. I want a party instead of, so that everybody can. And that's the important also of
This planning.
pre-planning.
Correct. Sylvia, we also talked about this in the past, but I think it's very important to discuss it again because not a lot of people know about this, about that asset threshold that you need to be under to qualify for some of the services. And that although planning ahead, and then there's different tools that you may use to be able to fall under that requirement, there's also things that you're not allowed to do to get there. Can you expand upon that?
Well, you're not supposed to be gifting your money away. So if you start, let's say you have $100,000 in the bank and you hear about this $2,000 minimum threshold that you have to be at $2,000 or less, and you gift away $98,000 to your children or to your favorite nieces and nephews, this is a no-no. It's a prohibited transaction prior to Medicaid planning. And I'm constantly asked, well, how much prior to? How much prior to? Well, you'd be surprised. There is a 60-month or 5-year look-back rule, but I don't know of anybody really that can't justify gifts, before 60 months. So that doesn't mean that in the estate planning world, we can't do a gift-giving program to children. I see that done all the time. But it must be for estate planning reasons, and it must be documented, and maybe there was a gifting program all along for every year to do the annual gift exclusion. When there isn't that kind of strategy in the estate planning world and you're just doing it in the elder law planning sphere and it's right before you apply for Medicaid, that's when it's a prohibited transaction to do that gifting.
Perfectly. So to recap, why don't we do a list of the do's and the don'ts in this area? What is the do for you?
Definitely do pre-planning regarding your funeral, burial or cremation, and cap the cost. How much do you want to be spent in the estate? Typically, if you do pre-planning, that's wonderful because it saves that grief for your family members.
How about in terms of the long-term insurance?
I think we all should do some planning in that area and purchase the long-term care insurance. I think it's well worth it. Unless, again, you're very affluent, and you have money to spare, and you don't need an insurance company to cover those costs for you.
Or if you're Superman and only kryptonite's going to go ahead and do you in.
Right, and always consult an attorney. Go to
That's
a person that
that's
knows
a
about the
big do.
topic.
That's a capital D-O, do.
That's so important because there are in the state of Florida many organizations and individuals who claim to be elder law planners, but they're really practicing in the area of unauthorized practice of law. They are not really capable, they don't have the legal knowledge to carry on elder law planning for you. So always seek the services of a competent elder law.
Attorney Ibanez, Judge Rodriguez, thank you so much for being with us today. We're out of time, unfortunately. The Conozca Sus Derechos show of the Hispanic Bar Association of Central Florida is dedicated to service and education for our community. In our upcoming episodes, we will continue to discuss important issues for you and your family. We wish to thank Orange TV for their assistance in bringing you this program. For further information, please visit hbacf.com. Thank you for tuning in.